Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Welcome back to Case Autopsy. I'm your host, Mike Campbell. Chris Finney and I delve deep into the second part of the interview with Nolan Drafahl. If you want to catch the first part, that's episode 15. If you're one of those people that doesn't mind jumping in halfway through, feel free to listen.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Another thing I'd like to mention with how I structured voir dire was I ended up getting to burden of proof and non-economic damages and stuff. I waited till later on that, okay? What I wanted to do was not talk about anything too controversial or that might have thought like I was being more of an advocate on or stuff early. Instead, I started with like Sari Delamont has this funnel method. And so what I started with was a question to try to get a neutral thing, right? But get a bunch of hands. Who here has ever gotten medical treatment at a hospital or knows somebody who has, right?
Everyone. Yeah.
Right. So right away you get some, call it audience involvement. And, some people even chuckle because they're like, oh, everyone's going to raise their hand. And I think I said, I think, everyone's going to raise their hand to this, whatever. And I said, well, for those, who have gotten treatment, I said, well, what did you expect from the hospital for yourself if you got treatment or, for your loved one, if they got treatment at that hospital visit or whatever? And you get people saying like, well, I expected the doctor to really listen to me, or I expected the doctor to, ask me questions and be really thorough because I don't know that much about medicine. I expect the doctor to be using state-of-the-art technology. I expect a doctor to run tests that are needed, not to guess about things. I'm like,
well, and these are
tests don't guess, right? And all these
principles you're getting from the jurors that talks about, hey, get 100%. Them from the jurors, and it's like write what you're talking about.
Yes, yeah. Her method is to try to source your principles from the jury, right? And then you talk about these in opening statement, of course, because it's much more effective if the jury's thinking like these are our ideas instead of something Nolan force-fed upon us, right? So and then you get into, well, what can, it sounds like this group believes that hospital provider should, be thorough, ask the right questions, take a detailed history, use state-of-the-art technology and run necessary tests, not guess about diagnoses. What can happen if a hospital provider doesn't do those things? And right away, some lady raised her hand. She's like, people can die.
Yeah.
Thank you for that. Anything, and so I just think that is such an effective method. And I will say again, when I was on this jury a couple weeks ago, I was selected as an alternate. The case ultimately settled later that day, but it was a breach of contract case, okay? And one of the attorneys did a very poor job, and one of the attorneys did a good job. And the attorney that did a good job was just very conversational, and he started with something just like that, kind of a broad, open-ended question that got a lot of people talking on a pretty non-controversial topic, right? Just like a neutral topic, things that you would expect. And I just thought that benefited him through the entire jury selection process.
So he kind of set, I don't want to say set his course, but when he kind of framed who he was right at the beginning as a kind of an approachable conversational person. And your point of view in that jury, when you were the juror, that carried through? Like that frame of who he was carried throughout, even into the trial?
Yes. And so then he also did opening, and then he put on the other attorney put on a witness and he crossed that witness. And so we got a little bit into the evidence. But the other thing with that trial that I was a juror on is, I just think this is such, like, we can't control when we're called for jury duty, but what we can do is we can volunteer at local law schools for their moot court competitions and be jurors when, students are putting on trials. And I just think you learn stuff in that seat. So,
well, what did you like? You're back. You're an alternate, but you're with the group, right? On breaks and stuff like that. I mean, peel it back for us. What's the discussion like? Are they the judge says, don't talk about the case. Are they talking about the case? What are they doing?
Well, no, they're complaining about stuff. They're complaining, like, in this situation, I was just a fly on the wall. I didn't tell anyone I was a lawyer. It didn't come out in jury selection. So
nobody read on your sheet that it said attorney or where you worked?
Well, no, none of the jurors knew that. So one of the lawyers knew I was a lawyer because I knew him, and I volunteered. That was the one time I spoke. I'm like, I know that lawyer, and there's no follow up by the other side, and so whatever.
Yeah.
So I didn't say like I know him because I'm also a lawyer. So anyway, when I get selected and I'm in the deliberation room, kind of just on breaks and stuff like that, it's just people like complaining about like how the blues tickets are more expensive, and it's just weird that like when you get some strangers together, they might like kind of tend to commiserate together.
Wow.
And I think every group of 12 to 14 people are going to be different. But what was interesting about that experience, I would say, too, was like the optics of it. In that case, it was a mom and pop Chinese restaurant that rented some space by this landlord. The landlord was a husband and wife. They were there in suits, and then the mom and pop Chinese restaurant they were like dressed down, and their daughter was in the gallery, and it was kind of like that David and Goliath. Yeah. Sort of, but okay, here's the big thing from this, okay? After jury selection and going into opening statement, and certainly after opening statement, I knew I wanted to find for the mom and pop Chinese restaurateurs. Okay, I knew that, right? And it's funny, we've all heard as lawyers that like 80% of people have their minds made up after opening statement. And even me being cognizant of that, it's just right. You can only do so much to control your mind, right? So
you're observing. So you're observing yourself thinking, how is my mind already made up? Yeah. Knowing that I should wait.
Make up your mind.
Right. So wait, so tell us about like how you have processed that. Like, why was your mind made up? Was it all the things you just discussed, which is a lawyer had credibility, the people looked like they were David fighting against Goliath, or was it?
Those were parts of it, and then it was the storytelling and opening statement. You had the landlord leading because they were the plaintiff, and it was this rote breach of contract, all that stuff. And then you get the defense lawyers defending the Chinese restaurateurs, and he's like, gets up there and he's like, listen, this is a story about a family that came over from China with a dream of opening a restaurant, and they worked their butts off to do it, 60, 70 hours a week. And they wanted this restaurant to be successful so that their daughter didn't have to make her way in the restaurant industry, which is a grind, so that she had other options and blah, blah. And then he gets into the breach of contract stuff, right? But again, it's storytelling, and it's kind of just, an emotional connection you might have, and you're thinking with one side of your brain instead of the analytical side, and that's the more powerful side. And I know all that stuff. Yeah, I know it because I listen to everyone talk about it, right? But it's still, you can't undo it.
It's Chris and I were at this thing with Rick Friedman and Bart. Well, so it was Bart got up and started giving this speech, and it was for the defense. And I remember thinking, I can't believe he's going to do this. It's for the defense. But I made this connection with him, and all of a sudden I was just like that. I was like, this guy's completely credible to me. I'd follow him off of a cliff.
completely disagree, like philosophically, but
Sure.
did you feel like I get sort of spooky when I talk about this. So sorry, but did you sort of feel like you were connected with this guy at some point? I mean, was it like, oh, wow, I feel like this guy gets it, and he's genuine, he's credible. You could sort of just feel it in your heart, mind, and soul, I guess, for lack of a better phrase.
Yeah, genuine, incredible, totally. And just seemed like a straight shooter, no frills, right? Which I think, like, again, he was conversational. He just didn't seem like he was the other guy. The other lawyer was wearing a bow tie, and he was just very like mechanical. And again, right? Like, as much as we, I think, can appear not to be like lawyers, probably the more likable we are, as most people don't love lawyers, right? Yeah. So, and Chris does a phenomenal job of that, Mike. When Chris picks a jury, he's just like, "Hey, everyone, what's up?" He's got this like kind of like this persona is just kind of us, and I'm going to cut to the chase. And like, I think jurors are probably just like, "Oh man, like I appreciate this guy. I'm cognizant of my time. He's talking to me directly. I don't think he's BSing me around."
And I think that one of the most effective things he did that I use now is, when he had the defendant on the stand, I mean, he was just like, "Well, it's going to be hard, but let's get to it," and it was like, he's laughing, but you're kind of like, okay.
I love talking about my trial skills, guys. Keep going.
Let's go. But there is that genuine connection you feel. And for me, it's like, we're all just sort of swimming in this thing together, and you sort of just kind of float to the person you're most connected to. And I think trial is the ultimate sort of arbiter of that. We get to throw ourselves out there and be exposed and hope people accept that.
So on that note, like, Nolan, what did you and Jeremy do during that week to kind of stay in the moment, or not to get ahead of yourselves and think, okay, it's 2:30 on Wednesday, I think we can, like, what do we got tomorrow? Like, what did you guys do? Did you have a conscious plan each day? Or was it like, hey, you've got this, I've got that, somebody pay attention here? What did you do to make sure that you stayed connected on the juror's wavelength?
Yeah, before I get to that, I will answer that. Let me just kind of tie up the loose end from my jury selection experience, which is an actual practice tip, I think. Okay, so last thing about that experience for me was I wanted to find in favor, but also, one thing that they kind of missed out on is I didn't know what the ultimate question was, even after opening, right? I didn't know what the jury charge was going to be and kind of where I needed to go, right? I was willing to try to get there, like, and kind of, just maybe give benefits of the doubt, or, do whatever, right? If there was any gray area.
It's like this Chris Hamilton stuff you're talking about, that we've talked about before, where he comes out and says, this is the question in the case. This is what it's about. You never got that from them?
Not from them. And I think you guys and I probably do that in our types of cases, right? Like, whether we're objectifying kind of what negligence means through like a rules of the road type of tactic or whatever. But I guess if we go into our cases thinking like we might have people, right? If we got a righteous case, we might have jurors at the end of our opening statements wanting to figure out a way to help our client. Make sure you let them know how they can do that. Because as you get into the evidence, right, the jury needs to know what the ultimate question is so that they have the framework through which to like assess the evidence. When we got into the evidence of the one witness before the trial, like, I was following it, but I'm like, well, how am I ultimately going to plug this in? What's the last question?
You're a lawyer.
Answer.
Right.
Yeah.
And you're a lawyer, and there's a charge, there's a one-page thing that's going to tell us what, and you're like, what the hell is it?
Correct. And because the issue there was, the claim was that this couple underpaid on rent for years because they supposedly, through agreeing to extra lease time, agreed to a higher rent. But the landlord didn't notice it until 11 years later, and then sends them a letter saying like, hey, you owe us $64,000 because you've been underpaying $700 a month. And I'm like, damn, that would suck. Is there any, what's the law on that, right? And what the law ultimately was, I learned after the fact, was to renew the lease per those terms, where there would be a step up in rent, that needed to be done in writing. And so it never was. Like the tenant just stayed there and the landlord just let them stay there. And so at that point, yeah, at that point you could just say it's a month to month and there's been no agreement of an increased rent. But I didn't know that, right? And so that should have been made more clear. So again, I guess like my takeaway from that is we need to remember like that some people might already be like in our case. Let's just make sure that they know what the ultimate question is so that they can find a way to get there, and that when they're listening to the evidence, they know what the ultimate question is.
That is a good point, because
Yeah.
they've got one sheet to fill out at the end of the day.
Right.
And
Yeah.
all the evidence they're going to hear really goes to that one sheet.
Well,
Yeah.
so I know Chris has an outstanding question, but we could do this all day. But so you give them the conclusion, they can backfill from the conclusion, like sort of that confirmation bias. I really like the concept of basically being like, the reason why we're here is the Rick Friedman, the polarizing, the moral compass, the moral core advocacy, which is they basically say my guy's a liar, cheat, and fraud. Right. And so I know that's not like effective in a contract case, but I'm just thinking out loud here. When you throw a moral issue out there like that, you sort of make the whole case about that. Are you saying that, maybe, you got to sprinkle in some like charges, I guess, do you think we have to enunciate or show them the charges in the opening statement? Or if you say something to the effect of, hey, look, we're here because they say my guy's been abusing drugs, or because he's a drunk, or because he has a criminal record and doesn't deserve doesn't deserve justice.
Well, I think the closer you can get to the jury charge so that they don't feel misled at the end of the case when they get the charge, if you say the question is this, probably the better, as long as the charge is an easy one to digest,
Sure.
right? Like,
Yeah.
if it's more convoluted, then maybe you would want to, simplify the charge and explain it more in layman's terms. And then you can kind of, in closing, have it up there and tie the layman's terms that you've been hitting all case into like how this is the exact same thing. It's just kind of stated more in legalese. But, some judges at the pretrial conference will want to see the parties' proposed jury instructions. And if you're there and the other side doesn't have like an objection to your verdict director, or if it's just kind of an auto case, it's a failure to keep a careful lookout, it's non-controversial or something, then you probably could show it in your opening, or maybe you just kind of say like, you're going to get at the end of the case a set of jury instructions, and the question you'll have to answer is, did this driver exercise the highest degree of care, or did he fail to keep a careful lookout and strike my client's vehicle and cause much harm? Whatever. I just think for me in that case, it was like hard for like I constantly kept thinking like, okay, you're making some good points, but like, what's the law going to be? Like, how am I going to match these good points and my feelings to my ultimate obligation, which is to follow the law?
It's like,
Yeah.
what do you want me to do with this information?
How can I backfill my conclusions here?
Yeah, exactly, Mike. Exactly.
Yeah. So now I'm thinking about this, and so I'm kind of seeing a way to this, because that's a very comfortable. That's something I feel very comfortable doing, which is polarizing, but then also basically saying, look, if you find for my guy and you find that he's credible, here's what you've got to do at the end of the case. You got to look at these charges and you got to be able to decide the following, because credibility, I think, in a lot of our cases is very critical. And I like talking about
thing.
Yeah.
I mean, it's like the case is always about credibility, right?
Yeah.
I mean, that's not just us saying it. That's all the big gurus saying it, but that's also our experience. And we've all had cases, Mike and I have, where our client wasn't very credible, albeit they're probably a great person down deep. They just couldn't get their act together, no matter how hard we tried for the case.
Right.
All
the gurus and Chris Finney.
It's one of those things too, where like if you can hear it a bunch of times from anyone talking on a webinar or podcast. But then once you feel like you've really won a case on credibility, it clicks in a way that it wouldn't have before, where you truly realize the power and that like people aren't just saying it just to say it, right?
And you look at cases differently now. Then you go back to your docket of your cases. You're like, ooh, I know that's not the biggest injury, but that has some serious power behind it and heat if we can get it to the right spot.
Totally. Yeah. And on this concept of, kind of backfilling, I actually I did that in the rebuttal close part of this med mal case. What I said was, where is it? As part of this, the whole point of catching, and we use the term cannot miss diagnoses because that was a term that their expert used, right? Which is great. I mean, you can't miss them. You got to find them, or the person's going to die, or they're going to be seriously hurt. So the whole point of catching cannot miss diagnoses in the emergency room is to catch them early when they're still treatable. Jasmine's small bleed, the warning bleed that she was having on Tuesday, is when this should have been caught. She deserved a simple head CT. She deserved to live. And then I said, so if you feel this way right here, and I tap my chest over my heart, but you haven't made up your mind about whether that is the right thing legally, let me tell you what I think is one of the easier paths to get there, so that you can leave this courtroom doing not only what you want to do, but what you should do under the law. Okay, so that was kind of my way as a lead-in to say, like, hey, if you're here, right, and you're still maybe on the fence, you want to find for our client because you feel like something's gone wrong and you feel like there's been a tragedy, but you're still a little stuck on how everything fits together. Here's how I see, with these jury instructions, the easiest path to do what you want to do and know that you're doing the right thing.
Is you're providing assurance to them that they're following the law. That
yeah.
What you're feeling is actually also correct.
Yeah.
You just read that off for us, but is that the transcript that you just read off of, or is that your notes?
Those are my notes, and I
you're not you don't read. Do you? Yeah, you're an approachable with the jury. You face them, but so is your practice to write it all out?
Mm-hmm.
That's what you do.
Yep. I wrote this, and mind you, it's a rebuttal close. And I'd say I wrote 80% of it. Some of the stuff at the very end, I kind of just had more bullet pointed. But when I initially wrote it, I wrote it out. And I've got like a pretty good memory. So if I write something and I read through it a few times, I start to kind of, in my own mind, shortcut things, and then it probably bullet points in my own line. And so I'm probably not reading this word for word, but I think most of it came out pretty well in terms of pretty close to how I had pictured it coming out. And so, yeah, I don't use notes, and I'm, walking around. I'm pretty animated, trying not to, and Chris, you and I have talked about this. In this case, my animations were more on the emotional side, not like the anger side. Like I do think like, anger can be kind of off-putting. So I've been trying to,
me and you both working on a lot of the anger issues.
Yeah. I'm trying to do less of that. I will say that during opening statement, like I teared up a couple times. Like I wasn't sobbing, obviously, but I'm such a baby in wrongful death cases. Like ever since I, had kids, I think like there was just some sort of like emotional, like I just, some sort of guard like went down on my emotions. But I kept it together very well on my client's direct, which I was kind of concerned that I'd a little bit there. But yeah, and then in closing, I didn't get too emotional, although like, again, the jury did, which was kind of how we structured closing. Was Jeremy did the first part and he was going to be more teacher mode, hit some of the high points with the evidence, but more so than anything, talk about the jury instructions and how the evidence matched with the jury instructions. And then in rebuttal, I was going to kind of, hit the emotional part of things. And I think that was a good.
Were the jurors, as you were doing your rebuttal closing, did you feel they were? I mean, obviously, you got an incredible verdict. Did you feel they were with you?
I felt that it was
following you.
I felt that it was a close case.
Yeah.
Everyone gave me their attention. A lot of head nods. But you know how it is. Like, one lady was nodding her head for both people, and she was ultimately one of the defense. And when I was in closing, she looked like she was sad, and I think she was. But ultimately, what we learned about her was she thought this doctor's career was going to be ruined. Yeah. So it would have been tough to read her as things went. But and I think I told you this, Chris. What worried me when we were, the jury was out for a while, was they never asked for our economist report, which was admitted. And during Jeremy's closing, when he went back through our economist numbers, nobody wrote them down. So when we got the verdict, we were like, well, we lost. Like, how are they going to get?
How could they get the numbers right?
Right. So we're kind of sad. We're like, we were obviously at 3.5 hours to talk, and our clients thought we did a remarkable job. I say clients because our client's husband was with us the whole time. And I'm like, I'm going to be disappointed, but I'm not going to lose sleep. Like, we really gave it our all. And we get in there, and the judge gets the, verdict form.
Did he give an eyebrow raise or something? What
did he do? He looks over to our table, but he's stoic. And I'm like, all right, get on with it. Right? It's going to be for the defendant. And he reads it, and he goes, plaintiff Danielle Young. And she just bursts into tears next to me. She's sobbing. And it's not for the money. It's for just it being over, her being,
vindication.
Kind of vindicated, right? Yeah, exactly, Mike. And she's sobbing. And so the med mal stuff, it's itemized, right? So he's got more to read. So, like, if you hear a pin drop other than her sobs, and he's like, so for past economic damages, right? And so it's like a longer process. And it was, and again, we just thought for sure we lost. So what we found out happened from the bailiff was that, the jurors were allowed to take notes. So one of the jurors had all the numbers written down from the economist's testimony. So, nobody wrote them down. And then when they got back there, they didn't need to ask for the economist's report because he had his notepad.
So I got a quick question, because I want to back up to something that Chris asked about. And I think it kind of ties in with, because a lot of the things you're talking about, which is throwing yourself out there in front of the jury, then also opening up a little bit and feeling emotions, all of those things are very scary to me. And Chris asked, I think earlier, about how, like, you had to stay present with yourself leading up to the trial. What are some of the things that are going through your head, and how are you basically either unwinding or saying, I really need to stay connected and not get too cerebral on this, and try to, show I genuinely care and I'm credible?
Yeah. I mean, the credibility stuff was, I guess, just something I kind of worked on when I kind of envisioned what my voir dire and opening would look like, and I put it together and stuff like that. And that was the day one stuff. So that kind of took care of itself there. And then during the week, we really structured our evidence in a way where we were trying to start the day strong and finish strong. Okay. And so if we thought that so-and-so witness might not be great, or this might not be interesting, we tried to put that in the middle of the day. And so it helps, Mike, if you can end a day strong, not to overanalyze stuff, right? We ended one of the days, I would say week, it was the day that I crossed the defendant doctor, and it just didn't go that well. My cross went longer than it needed to, and what I should have done was either shorten it up and stopped after a certain point in the cross. That was probably my apex, I guess, or just at least put that apex part at the end of the cross. Instead, it kind of ended weak, and like I said, the guy made a good impression. So that's one of the things, right? That goes to your point too, where trials can kind of be a little bit of a roller coaster. Sometimes you think you got them on the ropes, and they're like, wait, are we on the ropes? And did I undo this credibility? And all this stuff, right? So part of it, I guess, comes with just having tried a few cases before and knowing that you can feel like you're losing, but it doesn't mean that you are. Just stay the course, trust the process, and just know that tomorrow's a new day. You start fresh, and, so those were some of the things. And then Jeremy and I would meet every day. And this was the week too, Chris, you might remember we had 2 crazy storms. I think one was Monday and one was Thursday that week, or something crazy. So one of the days we're like going to do some more trial prep at a restaurant near the courthouse, and we're both under this big umbrella, and it's like pouring rain on us, and we're just like, let's just get somewhere and kind of talk through a few things. And I guess one last thing on that point is I try not to like burn the midnight oil during trial. I just think at some point you're getting diminished returns, and you want to give your best self to the jury, and you're going to do that obviously if you get a good night's sleep, stay hydrated, maybe do a little workout kind of thing. So
did you do that? I mean, and then it's like in those terms of logistics, I mean, did you get a workout in the morning or the evenings? Did you have lunch brought in? Did you bring your own lunch? What was your and Jeremy's like, hey, this is how we're going to handle the trial? Because I'm a believer you need to plan that out. Like, what's that week going to look like?
So Jeremy, as you know, Chris, is just a freak. So
yeah, he's just a maniac.
He's just kind of like a robot. He like doesn't need food or rest.
Yeah.
So he does his own thing. I brought like protein bars and waters and stuff like that for the trial day, and then I would eat like a healthier dinner. I got a couple short Peloton workouts in. The one night that I went way later than I wanted to was the day before I crossed that defendant doctor. I kept working on the cross outline, which, in hindsight,
diminishing returns on it.
I should have. Yeah, exactly. Yeah. But again, it's just it ended in a good way. So it's just, you could take it from me. You can feel like you got beat up in trial. It doesn't mean you lost the case. So just, again, try to stay fairly centered, I guess. And, until you get through it.
I want to talk about a specific moment. You're sitting there, you're getting ready to do the cross of the defendant doctor. Are you feeling some fear, some anxiety? And if so, what are you telling yourself? What are you thinking? Or are you just in the moment? You're like, yo, let's roll.
I was pretty in the moment. I'd say like I went into it here's the difference on that one, right? Like we just didn't have a lot from his depo for me to be able to be like, I know I'm going to get some good yes or no's on these questions, right? And if I don't, I can teach him with his deposition testimony. So in that way, I was a little nervous going into it, Mike, feeling like I was kind of flying blind, and just having seen how well he did in his depo, I was worried about that. And then here's the other thing, guys, which I don't have the answer to. On some occasions, I would ask him yes or no questions, and of course, he would just go on some soliloquy, and then you're stuck with the decision of, do you interrupt him? Do you say, hey, doctor, with all due respect, it's a yes or no question, or does the jury perceive that you're trying to like hide something by cutting off his act, And again, when it's a witness that presents well, it's a tough judgment call. And I did it a couple times. I let him go a couple times. And again, as I sit here today, I can't tell you what worked better and what didn't. It was tough. So
just knowing that I'm not the only person that struggles with that is important.
Yeah.
Right?
Yeah.
Where it's like I'm not the only one that feels like I'm getting steamrolled by this witness. And should I do the motion to strike as non-responsive? And then the jury's like, what's this egghead talking about?
Yeah.
Yeah. I already have that problem. Yeah. So, man, Nolan, again, this sounded like an extraordinarily difficult case. I know it was in St. Louis County. For people who aren't familiar, St. Louis County is not St. Louis City. It's not the quote unquote judicial hellhole where big verdicts come out of, unless you're Chris Finney. But it is not an easy place to try cases. And, you did this masterfully, you and Jeremy both. And I couldn't be more happy to have you on the show and to talk about this stuff.
Thank you, Mike. I really appreciate that. And again, I feel lucky to be on the show. So
yeah, cool. We are all very honored by Mr. Finney's presence. And we're just gonna keep hitting that. Look at that. There we go.
I will say before we cut it off, I talked to Nolan extensively after the trial because we were trying a case either a week or two after his. And we always are, the further we get away from trials, we kind of forget some things about what to hit and what not to hit. And, when he and I had talked, he hit these ideas of reminders of, tell the jurors what a verdict will do. And the verdict in his case is like, you're going to save lives. Like there's no question about it. You're going to save lives. And you can utilize that stuff. It's like, okay, that's true. Yeah. All right. I forgot about that. Right. When you're struggling with it, this will save lives. And it's even, you can't really say that in like a sore neck auto case. But when you have these big damage cases, you can speak honestly that, hey, you are going to save someone's life with this verdict. Yeah. That's what's going to happen. You're going to effectuate change. And those are the most powerful cases. And when you're going up with $0 offer, you get a $3 million verdict, which unfortunately gets cut down a little bit because of the caps. It takes a lot of commitment to the cause, belief in the clients, and also belief in yourself and your co-counsel to like, hey, we can make this happen, because I guarantee you 99% of trial lawyers are like, that is a very difficult case. And I am really certain defense counsel had no idea what came down when that verdict was there. Was the adjuster there?
The adjuster was there. So speaking of that, the first day of trial, the defense lawyers are like a dad and son.
They're pretty good. They're well respected around here about knowing what they're doing. They're
a boutique medical malpractice defense work. All they do is med mal defense. Oh. And the dad was upset with us about how Jeremy worked up the agency case. So this doctor there was two defendants. There was the doctor and then the staffing company that staffed him at the hospital, but the hospital itself wasn't a defendant. And so we had both of those defendants in, and Jeremy didn't really do a lot to work up the relationship between the doctor and the staffing company, but he did have the independent contractor agreement. And the dad was so mad. He's like, how are you going to get this agreement in? And Jeremy's like, well, the doctor said, he signed it, right? Like, we don't have to have the other signature of the contract on. He's like, well, he doesn't know what these terms mean. And I'm like, what are you talking about? Are you saying it's an invalid contract? Like,
he doesn't know.
What are you talking? So
this guy just signs stuff. You don't know him like I do.
So it was really heated. Remember, this is day one. This is morning of day one before we start jury selection. Okay. And he's like, you guys don't know what you're doing. You shouldn't be trying these cases. I don't want to try this case again because you get this in and it's going to be a mistrial and there's no chance you're going to win this case. He must have told us like in a 30-minute window, there's no chance you're going to win the case.
Perfect.
Then I start jury selection and we get to a lunch break and he's like, that was pretty good, young man. And I'm like, this isn't our first rodeo. This isn't our first rodeo. In the rest of the case, he couldn't have been easier and nicer to us. And then I will say one thing that happened, the verdict comes down, it's 5 p.m. The courthouse is pretty much empty. Our clients, hugs, we're talking a little bit and then they leave. Jeremy and I pack up and then we walk into the hall and it's quiet, and standing in a circle, around like a kind of a podium in the hall is the defense lawyers, the adjuster, and the doctor. And they were all silent. They were just standing in a circle, silent, like kind of like, what happened? What are we going to do next? And it's a visual I won't forget. And, I will say, like, I feel on some level bad for the doctor in that, he is a nice guy. Like he was stressed out about this. He told me after, when the jury's deliberating, he had lost 10 pounds leading up to the trial because he couldn't eat because of stress. And so the human factor is not lost on me, that like these are real people are being impacted from that. Obviously, my client suffered a much more profound.
I was going to say, 10 pounds versus a daughter. I was like,
Yeah.
hey, take your 10 pounds, bro, and relax somewhere else with it. All
But
right.
on one hand, and you guys know how it is, like I'm kind of using this just as an example
Yeah.
of like on a lot of these cases, the defendant is there and dealing with all this stress because their freaking insurance company won't do anything.
That's right.
They won't be reasonable to settle the cases, and these people have to, again, in like say the auto context, they made a mistake. They acknowledge they made a mistake, but they still have to go through the stressful process because the insurance company lurking behind the scenes isn't taking care of things the way they should. So, anyways, that's just me.
I think it's fascinating. It provides. We get in the arena, right, and there are other combatants, I'll say, in the arena, right, and the thing about our system of justice is that we don't. You're not going to go take something from his house. You're exchanging money for it, but it's still like it's stressful for everyone. And I think it kind of speaks to your character that you're like, hey, I understand what this guy's going through. And also the defense lawyer too. Like the defense lawyer is like, these young bucks don't know a thing. And then you come in and all of a sudden it's like, hey, we earn the old guy's respect a little bit here.
Yeah, definitely.
Well, definitely earned a little more than his respect after that.
Yeah.
So, well, Nolan, thanks a lot for coming on, and obviously welcome back anytime. And we look forward to hearing about your next multi-million-dollar verdict.
I look forward to hearing about that too.
Yeah. All right.
Thanks, Nolan. Thank you.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
That was a really wide-ranging interview. Hopefully you got to stick around for both of them, episode 15 and 16 with Nolan. If you have a settlement, verdict, or even a bad beat that you want to come on the show and discuss, please reach out to us. Also, we're always looking for interviews for Lawyer Minds. Like I mentioned every single time, you can get a backlink and push it out on your social. So thanks again for listening in, and we'll talk to you next time.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.